I think I'm the only person up here who has not been introduced. My name is Tom Kraus. I'm the Deputy Solicitor at the PTO, and I will be your moderator for this panel. And I think we can just get started right away with Jason Gardiner.
Great. So thank you. First, I just want to thank my distinguished panelists for joining me. This is actually a great opportunity for Marqeta. This is something we've actually been talking about for some time. The company is close to 6 years old, and we're actually very grateful for the USPTO to give companies like Marqeta the opportunity. We're a small technology company based out of Oakland, about 80 people. We work within the financial services space. So the ecosystem is made up of 4 primary players, and one of them is what we built, which is issuing and processing. So I'm sure all of you have debit or credit cards in your wallet. They have 16 digits on them if they're Visa and MasterCard. Those 16 digits, think of it as like an IP address. So when that card is swiped, tapped, entered online, whether you're buying something at Whole Foods or Amazon, those 16 digits correspond with a company like us. It literally routes to us, and we make a decision whether to authorize that transaction or not. So we're actually a very important and significant part of the payment card ecosystem. We also are inventors, so we have a lot of firsts in what we do, and we have 4 patents in process and been in process for some time. Alice, the Alice ruling has certainly affected us in a way where, we're not, I know there's been some word of, we haven't used the word patent troll, so I'm going to use the first company to use it. We've never been on the receiving end of that. Ultimately, the Alice decision was to keep that from happening, keep from companies that actually don't have a business plan and to actually implement technology, but companies like Marqeta do. We actually, we create the technology, we implement the technology, and it's up and running today. Several of the inventions that we made are first within our industry. We don't have, the wherewithal. Actually, whenever we have considered going after a company for infringing on our patents, it's really pretty much the last thing we want to do. And but at the same time, we have a competitive nature. We have investors, and really what we want to do is protect our IP, and obviously patents is one of the ways to do that. And Alice has certainly affected us in a way that keeps us from protecting that IP.
Okay, thank you, Mr. Gardiner. Alan Lowe from Google.
Thank you. Let me first thank and commend the USPTO for holding this roundtable and creating the forum for us to be able to discuss this important topic of subject matter eligibility of software patents under Section 101. My name is Alan Lowe. I'm Deputy General Counsel of Patents at Google. My team is responsible for building the patent portfolio to protect many of the groundbreaking software innovations that Google engineers make each year based on the literally billions of dollars of R&D investment that we make. Over the past decade, Google has built a significant portfolio, now over 50,000 patent assets, primarily concentrated in the software field. And because of that, we have a significant stake in the outcome of Alice and other decisions applying a subject matter eligibility standard. And because of that, we've given significant thought to the impact that this decision has had. And we also look forward to providing written comments following the roundtable. First thing I would say about Alice, and this really goes to sort of the general commentary that's been out there around it, which is that contrary to what many have said and claimed, Alice was not the death knell of all software patents or the blow to innovation in the software industry that some have said. As a company in the software space, Google continues to invest heavily in software innovation, as well as file patents on those innovations. The rejections that we've seen from the Patent Office and the decisions of the courts invalidating claims under Section 101 have largely been concentrated in areas that we would describe as primarily business methods implementing conventional computer techniques. Many important and vital areas of software R&D and patenting remain largely untouched because they've always been viewed and described as technological advances in computer technology. Such areas include computer security, video compression, and cloud computing, just to name a few. So in our view, as far as our portfolio is concerned, Alice only touched a relatively small subset of our portfolio. Instead, we view Alice as really, and the development of the law that followed Alice, as a needed course correction. The constitutionally mandated goal of the patent system is to promote the progress of the useful arts. We understand this to mean to encouraging investment and development in technology. Before Alice, too many patents were issued on claims, like those in Alice, to abstract concepts or functions performed on a computer or on the internet. Such patents often claimed a desired result, but provided no explanation or limitation of how to achieve that result using advances in computer technology. These kinds of patents have become the source of many litigations targeting software companies, whether it's large companies, small companies, resulting in resources being diverted from software innovation to having to defend spurious litigation. We think it is important for the Supreme Court to clarify that these kinds of patents should not be allowed. Applicants were basically obtaining patents based on no technical contribution and little disclosure to the public that they could then use to tax real innovation and real innovators that did the hard work of finding technical solutions necessary to bringing valuable products to market. The Supreme Court's Alice decision reminds us that it is not sufficient, nor should it be, to elevate form over substance by finding patent eligibility based on the mere recitation of generic computer components. The analysis must now consider whether the claimed invention is directed to technological advances in computer technology. And to be sure, Alice was a difficult opinion in many ways. It created initial uncertainty by focusing on a test for what is ineligible subject matter and leaving details to the lower courts to work out a test for what is eligible subject matter. But over the past 2.5 years since Alice was published, the emerging case law is now filling in those details. We now see the Federal Circuit in cases like Enfish, Bascom, and McRow examining whether a claim recites a technical solution to a technical problem to overcome the assertion that a claim is otherwise directed to an abstract idea. We believe this is the right question to be focusing on when considering whether a software claim recites patent-eligible subject matter. The technical problem solution test ensures that the patents protect advancements in technology, not some other field, and thereby promotes progress of the useful arts. This test promotes innovation in the software industry by rewarding concrete advancements in computer technology rather than a statement of vague results with little information about how the results should be achieved. As the Federal Circuit issues more decisions applying a technical problem, technical solution approach, the line between patent-eligible and patent-ineligible software claims will become more clear and predictable. This is the nature of the common law process on which our legal system is built, and we would want to allow the courts more time to work this out. In terms of how Alice and the standard applies to Google, we have found that when we draft applications and claims to clearly explain how the invention provides a technical solution to a technical problem, we draft higher quality applications that have a better chance of success at the USPTO and in other foreign patent offices as well. These applications explain the technical advantage of the invention in more detail and provide more information to the public, and the scope of the resulting claims are more clear. Like many companies, we are building a global portfolio. We file patents in the US as well as outside, and we see it as a hugely positive development that the question of software eligibility is now converging across multiple jurisdictions around this question of whether a claim recites a technical contribution. In conclusion, we'd like to see the case law, whether at the Federal Circuit or at the PTAB, applying Section 101 to software patents continue to develop with a focus on whether the claims recite a technical solution to a technical problem. With these developments underway, and we also encourage the USPTO to instruct examiners to apply the same test to claims in an application as also being fully supported by the current case law. With these developments underway, we see no need for action by Congress at this time to address patent eligibility of software claims and potentially risk creating more uncertainty and disruption in this space.
Okay, thank you, Mr. Lowe. Next, we have Daniel Nazer, Electronic Frontier Foundation.
Thank you. My name is Daniel Nazer from EFF. Thanks to the Patent Office for having us here. I always appreciate that even though EFF's membership and its views are not always aligned with the Patent Office, we always get a very respectful hearing, and I really appreciate that. We have about 27,000 paying members. At least a plurality would be working in tech, a lot in this area, and a lot of our members write software for a living. And we hear from our members pretty regularly about our patent work, and the feedback I get as the sort of chair on patents there is that we're too accommodationist, and that Alice doesn't go far enough, and that the rule should be no software patents. I'm not so naive that I expect the Patent Office to make legislative recommendations to the Congress along those lines, but I do think it is important that it's exposed to those views and those communities that are the people that write software for a living that are saying this, and that particularly in the free software community, there's a very significant population of people who are the creators and inventors in this field that feel that patents are a imposition on them and slow down their ability to create. But if you read Marbury v. Madison, it doesn't say that EFF members get to say what the law is. It says that the Supreme Court gets to say what the law is. So we live in Alice v. CLS Bank world. And we do think it is a significant improvement before the status quo, and that it was a significant change. And I think it's also, I agree with a lot of what other people were saying, that the question here, particularly for this event, is the big picture: is Alice beneficial or harmful? And the question, of course, is not just for. It undoubtedly creates challenges for the Patent Office and prosecutors and the Federal Circuit in its application, but it's a natural experiment. We saw in the Federal Circuit's decision, we saw a prediction from Judge Moore. She said that if these claims were invalidated, it would decimate the software industry. That's a direct quote. And did that happen? No, to the contrary. If you had invested in an exchange-traded fund of software companies the day Alice was decided, you would have beat the market very handily. You can check my work, look at iShares ETF. It's a basket of large software companies, many of which have very significant patent holdings, Microsoft, Adobe, and many of which don't, like Red Hat, that operate more in the free software world. So it's a quite balanced representative of the software world. That fund outperformed the S&P 500 by almost 100%. You would have doubled your returns if you'd invested in software the day Alice was decided. So I think we have to look back at the predictions of doom, and the conclusion is undoubtedly that they were inaccurate. So I think when the Patent Office is considering how it's going to look at reforms and propose reforms, that's a very important big picture thing to be looking at. And I also think in terms of the practicalities of Alice, we've seen it be extremely beneficial for smaller companies targeted by low quality patents. There was discussion from representatives from Amazon and Intel that I think gave good examples of that kind of experience. And at EFF, we tend to deal with smaller companies that are contacting us because they can't afford to call Fisher & Richardson. After Alice, we finally have some reasonably good news for them that it may be possible for them to defend a suit for less than the kinds of amounts that they were looking at previously, where you have claims that are clearly quite vulnerable to an Alice challenge, and you can bring a Rule 12 motion to dismiss. The costs are vastly lower than under the old world, where you really had to go through discovery and get to summary judgment and spend $1 million to defend a suit. And I think if you look at the kinds of cases where people have won 12b6 motions, many of them are just a rogues gallery of really low quality patents that were being used by the worst of the worst of patent assertion entities that had no business model other than leveraging the cost of defense. So we are big fans of Alice at EFF and urge the office to be cautious about seeking reform that would undo the good that it's done. To turn, if I have time, to topics about guidance, I think I understand that the Patent Office is looking at decisions that sometimes are hard to read together. But I think the most useful thing for it to do is to look at the language in Alice. And I think the provision, the updated section, I think it's 2106 in the MPP, could really use just some more direct quotes and some block quotes from Alice. And in our written submissions, we'll suggest what we think would be most helpful there. And we particularly think the office its guidance should include a clear statement and advice to examiners that in re Allopat is no longer good law. That if you look again to the Federal Circuit's decision in Alice, Chief Judge Rader explained under Allopat, this was an easy case. This is a specially programmed general purpose computer. It's patent eligible under Allopat. And I think that was right. And the Supreme Court clearly did not agree. In re Allopat is no longer good law, and it really was the rules of the road for a long time. I think the guidance would be really much clearer if there was an explanation that this is what the change was. So that's it. Thanks.
Okay, thank you, Mr. Naser. Julie Samuels?
Thank you so
Engine.
much. Ooh,
Go ahead.
that was loud. And thank you to the Patent Office for coming out here and for hearing from all of us and from everyone else today. I think it's been a really illuminating series of conversations. And one of the things I am here as a representative of an organization called Engine that works with very small startups, primarily in the high-tech space. And quite frankly, the vast majority of those startups are not dealing with the patent system necessarily because they want to. They tend to be very small. They maybe don't even have enough funding to have engaged in the patent process yet, even though many do have plans to do so, but they often find themselves on the receiving end of a threat of litigation or actually a complaint filed against them. And so what I really hope to be able to represent today are these two kind of crucial overlapping constituencies, which are these small and innovative startup companies, but also this constituency of people or companies or innovators, however you want to determine it, who find themselves working very closely with the patent system, but maybe not necessarily out of choice. And some people have already said this earlier, but I would just like to point out again that constituency is also a constituency of the Patent Office, right? That it's not just the constituency of patent holders that the Patent Office has to care about, but the constituency of innovators who are those who are pushing for the progress of the useful arts and science. And so that's kind of what I hope to speak to a little bit today. And I think conceptually there are a lot of people probably in this room, part of these conversations, who might even fault some of those companies for not doing more to interact with the system sooner, not filing patents even earlier, not engaging sooner. But the system was in fact conceived in a way that would incentivize that engagement through a robust notice function. And I think that many of us in the room know right now that particularly when it comes to software, the notice function is not working as I would argue it was intended. In fact, it makes that kind of engagement that's based on notice impossible, not just for small companies, but for quite large companies. I think even for Google, it's impossible to know what exists in the world of patents on the books. So there's some numbers out there on this, so they're kind of hard to find. There's a 2012 paper that estimates that in the software space, in order for patent lawyers to look at every software patent, even briefly for 10 minutes to determine if that patent might apply to the invention at hand, we would need approximately 2 million patent attorneys working full-time to compare every software-producing firm's products with every patent issued in a given year. And allowance rates have gone up since 2012, so those numbers, I'm sure, are even larger, which basically leaves companies with very few options, and this is, I think, why we often find companies who aren't more proactively engaging with the system and with the office. And of course, the second piece there is quality. We cannot have a conversation about the notice function, about proper incentives, without discussing the quality of the underlying patents. And among the small companies that I work with every day, we have seen quality improve since the Alice decision for a lot of reasons Daniel talked about, and I now get to as well. Because now a lot of these small companies have a tool to push back against threats that they face. And we've seen that time and again. So I want to talk for just one more second about the small startup companies. And some of these numbers actually come from Professor Colleen Chen, who you'll hear from later, so I hope I'm not stealing your thunder. But 82% of troll activity targets small and medium-sized businesses. 55% of troll suits are filed against startups with revenues of less than $10 million. These companies are generally lacking in resources to decipher vague and what are, frankly, often bogus demand letters, so these startups find themselves vulnerable. And these startups, new firms in particular, research that Engine did with the Kauffman Foundation showed that these new firms, these startups, are responsible for all net new job growth in the United States, so this is a very real concern. And what we're talking about is not kind of some abstract problem. It actually is a meaningful, it's a meaningful piece of the puzzle when we think about job growth and economic development in this country. And so what we've seen is that stronger 101 protections that we have seen in light of the Alice decision and in the past 2.5 years have incentivized the kind of risk-taking that we want small companies to make. The majority of those new firms will fail, but the ones that don't will create net new job growth, and we want to incentivize risk-taking. We do not want to incentivize infringement, that's not my point at all, but we want to incentivize growth of companies. And so when you have a situation where the majority of patents that are invalidated under 101 are cases that involve a non-novel or an abstract invention, that is actually in line with how technologists, and new firms work today. Those are the kinds of risks that we want to incentivize. So I've got a couple examples that come to mind, and I can't really say the names of these companies because most of the times it doesn't even get to litigation. But in the past couple months, I've heard from at least 3 small companies on both coasts who have, because of Alice, been able to avoid incredibly expensive litigation. In one instance, a group of companies came together. It was a joint defense agreement. They were able to draft an Alice 12b6 motion. They sent it to the plaintiff, and the plaintiff had sent a draft complaint, so nothing was ever filed. And when the plaintiff saw the motion, they dropped the suit because I think that plaintiff was rightly concerned about the quality of the underlying patent. In that instance, Alice is an incredibly powerful tool. And any efforts to dial that back that come from the office, that come from Congress, I think are incredibly dangerous for this country, beyond just for the patent system, but for these job-producing companies. While I'm on the topic of small startups, one specific suggestion I have for the Patent Office is I would love to come up with a world where we can better encourage interaction between examiners and the founders of these companies and the technologists at these companies, literally just in a social setting. Have them interacting more, talking about the types of technological problems, technological solutions that these companies are working on, so that when they come in front of the examiners, you've got more familiarity with what's going on. I literally think we should put these people in a room with a couple bottles of wine more often and just let them hang out. I actually think that would go far toward dealing with the quality issue, because I think people would just have better aligned incentives in those instances. Another question had to do with investors and investment. I work with a lot of investors, a lot of the VC community. To be fair, there's some splits in the community. Most of the venture capitalists I know who invest in high-tech and software companies don't have much love for the patent system. They see it as a drag on the economy. They see the patent troll problem way outweighing the benefits of patenting on the small companies. I'm being mindful of time, but there's a lot of detail out there. I know you heard from Professor Robin Feldman this morning. I unfortunately got here a little bit later. She's written on this some really interesting stuff, which I'm happy to share, and we will put in our written comments. And finally, there are just a couple things that came up in the request for comments that I did want to talk about. We talked a little bit about, and this has come up a bunch today, more consistency is needed, but I would just like to echo other panelists who have said that this is how case law works, this is how common law works, and the process is working. And we are getting more and more clarity as the years since Alice go by. So we're excited about that. One thing I also, this will be my last comment. Well, I have two quick comments. I feel like the request for comments was really focused. It started from a premise as if Alice were bad, and I think there are many people here today, I think there are many people, particularly in the tech industry that I work in, but beyond that, who actually think Alice is great. So with that, I would also say I don't think we need legislative changes when it comes to 101. I support Alice doing its job. Thank you.
Okay, thank you very much to those panel members, and we hope to receive written comments from all of you. It sounds like some of you have promised those already. If you have questions for the panelists, put them on the cards. They'll be collected. I can certainly start with a question or two. I was intrigued by the suggestion of a wine party with the PTO. I'm not sure if we'd all be invited to that, but as you're talking about situations where your clients, the people you work with, are seeking patent protection from the patent office, and you're hoping that they could interact with the examiners on that basis? Or did I get that backwards?
I mean, I think that the benefit would come from examiners. I think the benefit would come from both sides of the coin. But on the one, from the perspective of the patent office, I think if the examiners were to spend time kind of understanding the types of companies that a lot of these founders are building, the types of challenges they were facing, and understanding what that looked like, I think that when a new technology came across that examiner's desk, even if it's in an art unit that examiner is really comfortable with, these things are new, right? The idea of these inventions that come to the patent office is that they're new. I think it would be helpful if examiners had a better kind of idea of the context in which those technologies were being built. And I think the flip side, I think that a lot of people from companies would benefit to understand how the system actually works. Because when you are particularly at a small company, these companies, they don't have general counsels, right? These companies are tiny, and a patent, that sounds great, maybe, or dealing with this, that's a luxury for a lot of really small, scrappy companies. So I think if you create a space to basically increase the connective tissue between those two communities, I think everyone would benefit.
Okay, but you're mostly talking about a community that's not actually is on the wrong side of the patent game, in that they're more likely to be sued for patent infringement than applying?
That's what we've seen.
Okay.
That's what we've seen.
Let's see, and then I sense certain tension, I guess, in the positions that both Mr. Nazer and Ms. Samuels had, even compared to the other two panelists. And I was curious, Alan, we heard from Daniel that a lot of software engineers just don't like software patents, and we're hearing that kind of from Julie as well, and we heard that earlier today as well, and yet you say there is a space for patenting in the Google Corporation. Do the Google engineers agree with that philosophy, that software, if it provides a technical solution, should be patented?
Tough question. They said you asked tough questions. I heard that from this morning.
That's why I'm here.
I think there's different views philosophically on whether software should be patented. You have a lot of people who come from the open source community and have ideas and views and philosophies around what should be the case, whether it be various types of protection, including patents. I think what is very clear, and this is why you hear tension and you hear different points of view, is that there's a balance that needs to be struck between providing not too little protection, but not too much protection. And I think what Alice, from our perspective, did was it helped shift things back to becoming more balanced. There was a point in time when too many patents were being issued on things that were abstract, and companies then had to deal with this from an infringement assertion standpoint. And by providing more balance to the system, we have not eliminated software patents, but we've just in some ways clarified and raised the bar in terms of what it takes to get a software patent, and ensured that the point of getting patents and the standards that should be applied need to help achieve the purpose of the patent system, which is to promote the useful arts. And I think we're still working through that. I think the big challenge that we saw in the first year or so post-Alice was examiners not knowing how to apply that. And so we saw lots of rejections under 101 with no opportunity or ability to try to prosecute those claims into patentability. What we are seeing now, because of Federal Circuit cases, is more of an evolution and more of an understanding of, okay, now we not only know what is not patentable or what is ineligible subject matter, but now we're starting to understand what is eligible subject matter. And what I would encourage the USPTO to do with the examination core is to continue to look at the cases, and from our perspective, it really is focusing around technical solution to a technical problem. We think that's a positive recitation of a standard as opposed to a negative recitation of what's not patentable. And I think it gives something for all patent applicants, something to shoot for in terms of how to get a patent allowed.
I just, really quickly, I don't think that the majority of companies that Engine works on behalf of would argue that there shouldn't be patents. I actually don't think that's the case. I think that the system, engaging with the system can be so incredibly overwhelming at the outset that it is, it's this kind of proverbial put your head in the sand. So I actually don't think that tension entirely exists, and I agree with everything Alan just said about Alice helping get back to a place of balance where we do want to incentivize the kind of small companies I work with to effectively and responsibly engage with the system to, where appropriate, apply for a patent. But I think right now, most of them just kind of feel like, oh, I can't handle this right now, this is too much.
Yeah, I mean, if I can comment on the same. So I don't think there's tension. I think there's sort of two sides to the coin. So, Alice would certainly help companies like us in that it protects, companies whose business plan is, there is no intention to actually invent. It's just an intention to drive revenue by suing small companies. But on the other hand, I mean, the patent system was built to encourage innovation. So as an inventor, when we go out and build things, we're not required to get a patent, but if we want to take advantage of the patent system, we can go and do that. The issue with Alice is it kind of threw the baby out with the bathwater, and now we're finding out, over a couple of years now, we're seeing that companies like us are actually affected by the process. Now, if we want to invent and go out and have the right to pursue a patent, we should be able to do that in the spirit of why the USPTO and the Patent Office was actually created, was to allow inventors to go out and to invent. So, I mean, there are some reforms that we thought about ourselves, like venue selection, discovery procedure and cost, staying cases to allow the USPTO to complete invalidity changes, enhanced pleading standards, damage limitations, and most importantly, enhancing the ability for unfairly accused defendants to get back their attorney fees and costs. So there are definitely measures to strike the balance, and I think that's what you're seeing here. Daniel was talking about, ETFs and the S&P. These are public companies that can use market forces against small companies. Now, if we were going to throw out all software patents, that really levels the playing field, so that everybody can go out and build. I actually would be supportive of that, but clearly, that's not going to happen. But if companies like Marqeta, it's actually spelled wrong here, it's a Q, not a G, just in case you're looking for us. If we want to go out and pursue a patent, we should be able to do that, especially if we're inventing. And then obviously the USPTO has a process to take us through to make sure whether that patent is going to be issued or not. But in regards to Alice, it actually affects us positively because it protects us from trolls out there. But it also affects us negatively because it doesn't really allow us to invent and protect those inventions, which is the whole essence of why the USPTO was invented.
Would you describe your inventions as meeting the test that Alan articulated? Are they technical solutions to technical problems, or are they more of these conceptual inventions?
They are very technical solutions because we're using software to affect the financial services, which everything moves very, very quickly. So speed is all about algorithms and how we go build things. So we have mathematicians, physicists who go out and build, literally write computer code to solve that. So I believe we apply to that standard But, as Alan mentioned, what the difficult part is we get these responses back from the USPTO, and we really don't know how to respond to them, saying, well, we actually did that. We actually put the right language in there. We feel like we wrote high-quality patents, but the rejections we're getting some are based on, prior art, which we're defending, but some of them just don't make real sense to us, considering that, we not only applied, a certain standard to writing the patent, but we're actually have implemented this. We're actually using it in our technology. We're affecting, not only the startup ecosystem who's leveraging our platform, but also very large public companies which are using our platform. We feel like we should be held to a different set of standards because we actually implemented that.
Do you have some kind of a legislative language in mind for us to take that into account, or how would we actually take into account the difference between someone who's actually implemented the invention and somebody who simply hasn't?
Well, I think that's one of the standards. So if we've actually implemented the invention using computer code, I think that's one lens to look at. I think going to Congress is probably the last step. I frankly think that the ecosystem itself and the USPTO could probably come up with a set of standards before doing that. But I'm on the side of I want to be able to get my inventions approved, but at the same point, Alice certainly protects the startup ecosystem. It certainly protected us in the beginning when we were going out and building our technology. So there's certainly a balance there.
Okay. Daniel, you didn't have a chance to respond directly to Alan. And so do you think, I think you did say the EFF philosophy is software shouldn't be patentable, and Jason actually said he could accept that. Feel free to answer with or without reference to the First Amendment.
Yeah, I mean, I think there's some big philosophical questions that the free software community believes that if you're writing software and you're not copying someone else's software, obviously patent's very different from copyright in that you can kind of collaterally attack someone, that you haven't free road on their work. And I think within the free software community, even if you could prove to them that the patent system was actually better and that it incentivized more work, they still wouldn't be moved by that because it's a personal freedom question for them. And I think it was interesting for Alan, like within all these companies, there are going to be people like that who have that view. At Google, it's obviously not the company line. I think from the patent office's perspective, you're not going to necessarily be moved by that, but you will want to look at the big picture in terms of, well, is the system in a particular area working to incentivize innovation we wouldn't otherwise have? Or I think it was the gentleman from Amazon who said, or are we getting patents that are taking more out of the public domain than they're giving into the storehouse of knowledge? And I think Alice worked very well in terms of as to computer-implemented inventions, as to improving that calculus, where previously you could say, just do X with a computer, and you claimed all means, so you're raising kind of 112 issues as well as 101 and 113 issues perhaps, but that definitely the patents that Alice is most clearly undermining are the patents that were giving the least value to society. And so I think even leaving aside the kind of philosophical free software perspective, I think Alice is independently and very important for that reason.
Okay.
Yeah. I have a question regarding, Alan, you mentioned the technical problem with the technical solution, which is reminiscent of the EPC approach to the eligibility issue. And to me, there is a nascent question underlying that, in that you sort of have to define consensus of what is technical, right? And so if we have the aim of a one-size-fits-all solution in our patent eligibility statute, do you have any insight as to what we could do to better define what is technical?
I mean, it's something that and many large companies that file abroad have to deal with now in Europe and in other places. And we're seeing this show up in China and India and other jurisdictions as well. The whole reason for coming up with that standard is to allow flexibility. I don't think there is a way to describe technical in a very broad sense and have that be something that everyone understands how to apply. But if we at least have that concept built in, what we're really talking about is that and you know, Jason said, you know, in his case, the inventions from his company are very technical in nature. We kind of have a sense of what that means, and we have a sense of what it isn't. And when we see the kind of patents that we've seen that are very broad, that have, you know, very thin specifications, and are very results-oriented with nothing fleshed out in terms of detail, we have heard many stories and cases of inventors, and I use that in the very loosest sense, just, you know, sitting around a dinner table brainstorming ideas and just filing patents on these things, and then going out and enforcing them. There's really nothing technical about a lot of what those patents contain. So while I don't have a very specific answer to the question, I think it's something that would need to be developed, and I think could be developed, because we've seen it developed in other jurisdictions.
So just a quick question related to that. So obviously, before Alice, you know, in the U.S., we could get a much broader claim than you could in Europe, per se, you know, because they've had their technical effects standard now for quite some time. We saw in the earlier panels today that we have a lot to learn, that we, you know, it's a recommendation for the U.S. system to learn from what other countries have put into their laws. And then we saw the side-by-side comparison in at least the life sciences example. But even though we can't get as broad of a claim in the software space as we could pre-Alice, now with the two-step test and the evolving case law that we're seeing, you know, post the Alice decision from the Federal Circuit, what is your sense? Generally, you know, what I'm hearing is you could still get a broader claim in the U.S., even with the current two-step test, than you can in Europe, compared to their technical effects standard. And just curious what your thoughts are. Is where we are today, you know, more restrictive, less restrictive, or about the same as in comparison with the European standard, or perhaps a standard from another office?
So
Direct it
my
to
2
Alan,
cents,
yes,
I'll just run my 2 cents. I'm sure these guys have their own thoughts as well. I think it's still evolving. I think it's early days to be able to say it's more restrictive, less restrictive, same right at this point. But I think what's clear is that the data points are in play now, and it appears that the Federal Circuit is starting to coalesce around this standard because it's showing up. And we've seen this, you know, going back to, you know, decisions and concurrences, dissents by Judge Newman from the very early days of the court around this subject matter, this topic of 101. So this isn't a new concept in U.S. jurisprudence as well. It's just now starting to take shape and form because of the Alice decision. It now has meaning. And I think we'll have to wait the next couple of years to see how it plays out. I think the important thing, though, is that the office recognize this standard and think about how it wants to provide guidance to examiners so that applicants who are now applying for applications have the right ability to be able to prosecute with an examiner and apply this now evolving standard rather than waiting too many years and just get blanket rejections without any direction or guidance from the examiners.
I haven't followed the international decisions super closely. I know in Australia there's been some decisions that have kind of, like the Federal Circuit, have gone a little following Alice and citing it approvingly and otherwise distinguishing it in a way that that gives it less truck. I do think the technical effects at some, I think there was a decision out of the Central District of California that had a sort of, you know it when you see it take on Alice, and I've certainly seen in Australia some decisions like that. There was a patent application that we wrote about at EFF that was granted on filming a yoga class, and the innovation was the camera was placed at the back of the room, you know, in a studio with a floor, you know,
White walls.
yoga
I think it had white
studios, and the examiner couldn't find anything about a camera at exactly 4.5 feet high, and in Australia they ran the same application, and the examiner was like, "This isn't a technological innovation. This is just filming a yoga class." It's certainly a tool. I know our EFF, it was before my time at EFF, our amicus brief in Bilski was along those lines. But
I would just add one more thing when you're talking about international standards. And earlier today, at least one person brought up TRIPS. But, thematically, over the course of the day, it's been clear that different industries, by and large, have different feelings on where 101 jurisprudence is and where we are post-Alice. And I live in the real world, and I understand that we have a one-size-fits-all system, but I think conceptually a lot of people could agree that sometimes that doesn't make that much sense. And I actually do think if you looked more closely at TRIPS, there is a real argument for treating software inventions differently. I think you could do that under TRIPS. I think that, we've been patenting software not for a very long time in this country. There's a history that is significantly shorter than other types of technology. And so I think that there are very real and very serious growing pains in this industry. And I think that to the extent we have a one-size-fits-all system, we need to address those concerns. And other industries, it's not going to be perfect for everyone, but I think that's a very real thing that's why you guys get paid big bucks.
Do you think we could say no software patents whatsoever consistent with TRIPS, even if they embody technological solutions?
I think that there is a real argument that you could say that consistent with TRIPS, yes. I think politically that would be a lot harder, but I think that intellectually and I think you could do that, yes.
Certainly New Zealand has.
Yeah.
If you look at the law New Zealand passed about 2.5 years ago, they're a TRIPS signatory and was a pretty major reform on software patents.
So I have a couple questions from the floor that I'll paraphrase here, but essentially I think they're trying to get some free legal advice from our distinguished panelists. But what advice would you all give to a software startup company post-Alice?
Well, as a software company post-Alice.
Yeah. There's your guy.
I think well, first off, it's being involved in this. It's like the fact that the USPTO had, put together the day in Virginia, put the day here. There is a general concern about, the current system and how Alice has affected it. So I actually have been recommending, and it turns out, spoken to a couple other CEOs who are just as worried as I am. One, the CEO of Cabbage wrote a book. He's actually involved in, several, at least locally in I think it's Atlanta, Georgia, around patent law. So I would recommend getting involved. And I would recommend, if you feel like you have something that merits patentability to enter the process. The hard part is this, how do you write how do you create the subject matter for a patent? I mean, when I sat down with our patent attorney to actually write a patent, she was talking about, subject matter and the things, it felt like it was speaking another language. So actually sitting down and taking what we write in code and put it into something that is actually patentable. So that actually process was great. To be able to do that. So as I advise a lot of small companies, also advise investors, and some investors are on, as Julie mentioned, some investors are on one side where they don't like patents at all because it frankly affects the companies that they're investing in, and Alice has actually protected them. But at the same point, your valuation goes up. I mean, if you do have a patent, whether in process or not, if it's been rejected or approved, I mean, it increases your valuation. Of course, if you go through a liquidity event, whether it's, especially if you're being acquired, larger companies acquire companies for their patents. And there's a promise there. So I think definitely as, small technology companies, if they believe they have something that fits the standard, then they should actually absolutely go and go through the process of getting a patent.
I think for us, it's really the big impact that we've had to, the big change we've had to make internally, which is how we draft applications. And again, because it's not about Alice saying that you can't get patents on software or computer-implemented inventions. It's about whether or not there's a technological solution to a technical problem. And the more we can disclose technology and technological advance, the more we can show the technical effect, the more we can ensure that the claims reflect that, then I think the higher the likelihood that a company I would advise or our own company will be able to get a patent allowed, whether it's from the USPTO, the EPO, or other jurisdictions as well. This is the thing for us that I think that goes a little bit and I mentioned it, but I just want to sort of mention it again, having standards that are more similar, not exactly sure whether they're the same or one is slightly more liberal than the other, but closer, it simplifies things for us, because now we know how to draft applications globally, as opposed to let's draft a case for the US and let's draft a case for everywhere else. And so having the standards start to converge makes it more uniform in terms of our ability to make sure we're protecting our software innovation.
Julie, you mentioned that venture capitalists aren't looking necessarily for patents anymore, and yet you just heard Jason say that patents can be an important component of the valuation of a small company. Do you have statistics to back that? And we also heard anecdotally. Go ahead.
Yeah, I've got a couple, I think, in my notes here. And these are from a paper that Robin Feldman put out. So, like I said, I believe she was here earlier, and I missed her. I don't know if she talked about this at all. She surveyed 200 VC firms. 70% of venture capitalists have portfolio companies that received demand letters. The, quote, vast majority of claims came from companies that, essentially NPEs, non-practicing entities. This study found that existing patent claims could be, quote, a major deterrent to investing in startups and cost on average over $100,000 to combat. There was another study by Catherine Tucker, I believe, I might be getting her name wrong, I think that's right, and I can include that in my comments, that estimated, in fact, that VC investment in startups would have been $8 billion higher, but for troll threats. That was the 5 years previous, and I think that study is now 2 or 3 years old. That really has to do with both, I think, of the numbers I have with me right now have a little bit more to do with troll activity, but you can't separate the two. So what I have seen personally, and what some of the data I know has kind of pointed out, is that the deterrent effect of bad actors armed with low-quality patents has been a real impediment to the flow of venture, the flow of investment. And while I don't disagree with Jason's point, and I think that there are always going to be investors who look for, for IP value, that's a real thing. I wouldn't pretend otherwise. We have seen that the negative consequences of particularly pre-Alice kind of, software patents has been incredibly problematic. And I can also say, this is a little bit more anecdotally, I work very closely with a lot of venture capitalists, and the vast majority of those folks that I tend to work with don't look for a patent portfolio as a determinant. They look for network effect, they look for a business that's in the marketplace, that's doing well, and if there's a patent, great, but that tends to not be the driver alone. And I think pretending that patents as a driver for investment alone in the software space is, I think, a potentially dangerous path to go down.
Okay.
Yeah, just to point out, I mean, we're talking about Alice protection versus Alice impact. We're impacted by those decisions. There are plenty of startups out there that are protected by those decisions so that they're not seeing, getting the receiving end of a demand letter from a patent troll. And we have one of our strategic investors, one of the reasons they actually invested in us is because the patent portfolio we have, even though it's in process. Because some of the things we're doing, Julie mentioned network effect. I mean, we don't necessarily have a network effect. We provide a very technical platform to companies that want to build credit, debit, and prepaid products. So that is very technical in nature, and that's what they're leveraging.
But you can't separate those two things, right? You can't separate.
Oh, yeah, for sure.
Right. Somehow we have to find a place where it all works together.
Yeah, so when we meet with VCs, I mean, we meet with somebody who understands how the financial ecosystem works and knows that there's a lot of, technical inventions and code and things that go behind that, not necessarily a network effect, but for sure.
One some more anecdotal story I would tell, to the way that Alice helps smaller companies is MPE activity was very active right around the time Alice was decided in apps for restaurants. So just providing menus and pretty basic apps. But when you have a big customer, it's a pretty big job to create these apps. And we had small companies were coming to us because suddenly their work was drying up because the larger clients were demanding indemnification because the market was getting hit so hard by PAEs that no one wanted to do it unless they were getting a giant company to provide these services so that they could indemnify. And it was just washing the smaller companies out of that field, and a lot of those particular PAEs have subsequently had their patents invalidated under Alice. And so I think that was a really sort of encouraging event for that ecosystem.
Okay, this has been great. We got 1 minute left. I've got one question, 15 seconds each. It sounded like every single one of you was not in favor of a legislative fix to this problem, to maybe codify Alice and put some clarity into this aspect of the law. Did I understand that correctly? Go, Julie.
With regard to, I think there are a lot of legislative fixes the patent system could use. When it comes to 101, I don't think we need legislation.
Daniel?
Yeah, I don't think the legislation I would want is what's on the table, so I'm going to say no.
I generally would not favor legislation, particularly in order to allow the courts to have more time to work through Alice.
I would see it as a last resort if we had to get a legislative fix. But yeah, if we can work it out ourselves, then by all means.
Okay, thank you very much, all of you.
Thanks.
Thank you.
So we now have a 10-minute break, and then we'll be back at 3 p.m. for panel number 6.